indeed a pleasure. It's indeed a pleasure to have this session in association with the Panipat Institute of Engineering and Technology. It's indeed great that we've got these colleges and students joining us, together for this session. And it's a part of a journey towards entrepreneurship for the college students and to understand the ways and the means that they could protect their interests and their inventions and their innovations. It's indeed a pleasure that PhD Chamber of Commerce has today organized this session along with a whole range of eminent speakers that we have today who could progress, who could in fact benefit all these students. We've got Kundan Lalji, who's the Assistant Director, Government of India, Ministry of MSME. And we've got Shweta Sen Thalwal ji, she's the founder and head IPR, Integrim IP. We've also got Ms. Deepika Divakar Penekar, and she's the co-founder, Logjeevan Pune. And we've also got Dr. Prabhakar Bhagwat. He's the Principal, Department of Pharmacy, Panipat Institute of Engineering and Technology. And at the very onset, I would like to welcome Professor Dr. Shakti Kumar, Director and Program Coordinator, Panipat Institute of Engineering and Technology. May I please request Professor Dr. Shakti Kumar to give his opening remarks, and therefore then we can take the session forward. May I please request Dr. Shakti Kumar. Dr. Shakti, are you there?
Thank you. Thank you, sir.
Welcome.
Could I get the sharing rights, please?
Yes, sir. You can share your screen. Or we can see the presentation, sir.
The esteemed dignitaries, the keynote speakers, Dr. Bhagwat, the principal, the distinguished guests, it's indeed a pleasure to join you on one of the very important topics of the day that has got a direct bearing on our prosperity. I'll not be talking much on the patents. Nevertheless, my topic will be focused for a few minutes on significance of intellectual property in the growing artificial intelligence and healthcare industry. We all know we are in the middle of the 21st century, and we say the 21st century is the century of knowledge-driven industry. And when we talk about the knowledge-driven industry, we talk about that there are two very important things today. It's the data and the knowledge. Data drives the knowledge, and knowledge drives the economy. And this is where the intellectual property rights assume the highest significance as far as the economy is concerned. If you talk about the healthcare center, and if we have to talk about Niti Aayog's investment opportunities in India's healthcare sector 2021, the predictions for 2022, it says the healthcare market will grow to about $372 billion, which is a huge market. And because it is a huge market, we need to exploit. Am I audible?
Yeah, you're audible. Please go ahead.
So we need to exploit this huge market towards earning revenues for the nation, for the society, as well as creating a lot of job opportunities. If we have a look at the global private investment in artificial intelligence in the year 2020, we find a drug discovery, biomolecular engineering, cancer research, drug. This is the area where more than $1,400 million, $14,000 billion are being spent. So almost $15 billion was spent in the year 2020. That gives us an idea that which way the things are marching ahead, and where we shall think about, talk about, and where we need to focus. And if you have a look at the Forbes Insight survey, I think last year it was carried out. About 300 plus executives participated in that. And in the survey, it was found that almost 95% of the executives said that AI will play an important role in their responsibilities in the near future. And the most cited business benefits out of the AI, which the corporate leaders mentioned, were almost 40% will increase their productivity, and 28% said they will go with the artificial intelligence because it will reduce the operating costs, and 21% said there will be improved speed to market for the products, and 20% said it will transform the business and operating models. So more or less, almost every executive said artificial intelligence is a technology to watch. We are in the middle of Industry Revolution 4, and we also say we are in the middle of cyber physical systems. And when we talk about the cyber physical systems, we talk about the driving technology to the Industry Revolution 4. And on the top of the agenda, we find it's artificial intelligence, Internet of the Things, robotics and automation, big data, blockchains, augmented reality, virtual reality, 3D printing, quantum computing, and communication technologies are driving this revolution. So since the revolutions are required to be exploited, because otherwise we will be left behind, there's a lot of surveys being carried out which tell us that there is a lot of GDP gap per capita. If that gap between the developed and developing nations is not reduced, that meant if we don't exploit Industrial Revolution 4, we are likely to be entering into the slavery once again. So one needs to be very, very cautious that whatsoever field we may be working in, the Industrial Revolution 4, it's driving in the emerging technologies. And in that, artificial intelligence assumes a very, very significant role. And if we talk about artificial intelligence a little more, we find in 2016, we have about $4 billion market for AI. And by 2025, it will turn out to be about $160 billion market. And since 2000 onwards, there have been 1400% increase in the number of active AI startups. And investment in AI-related startups have increased about 6 times since the start of the millennium. In the past 5 years alone, the percentage of the jobs requiring AI skill sets have increased by almost 450%. But this topic is all about patents and healthcare industry. Why am I talking about AI? There is a specific reason behind that. And also, if you have a look at the United Nations Conference on Trade and Development in the technology and innovation section, they say that the AI market from 2018, which was in 2018 was about $315 billion, that will rush to about $3,200 billion by 2025. So it's a market which is gonna affect every nook and corner of our lives, whether we are talking about our offices, we are talking about the industry, we are talking about the agriculture sector, or we are talking about the healthcare sector. AI is gonna have perhaps the biggest impact on our lives as well as on the healthcare industry. If you have a look at the number of publications, also we find AI had got the largest number of publications in the last few years. And if you talk about the patents itself, we found AI has got the largest number of the patents that is in the offering for us. That meant the new innovations the new patents, the new intellectual property that is emerging in the frontier technology, that's AI, including the healthcare sector. And if you talk about the service sector contributes to about 46% of India's GDP, in which the healthcare sector is gonna play a very significant role. That meant healthcare sector needs to be revolutionized with the upcoming emerging technologies, including artificial intelligence. The amalgamation of artificial intelligence and the healthcare system is perhaps one of the things to watch, where a lot of intellectual property can be generated. And as I stated earlier, it's the data that drives knowledge, and it's the knowledge that's gonna drive economy. And when we say it is knowledge that's gonna drive economy, I'm saying it is the intellectual property, accumulation of intellectual property, including patents, that's gonna govern our prosperity. AI plays a tremendous role, a very significant role in the healthcare sector. You go to any of the top hospitals, this is one of the pictures from PGI, perhaps PGI Chandigarh. But if you go to any of the bigger hospitals, you find this kind of lines are there, and artificial intelligence is required to step in and ensure that these lines are no more, and everything and anything is available to the people at home without wasting time in the line. So in the healthcare, AI will have a bigger role to play, and the amalgamation will ensure that the large number of the intellectual property comes out of this. Another example comes from the IBM Watson. There was a study carried out on 1,000 patients, and IBM was asked to suggest treatments for these 1,000 cancer patients. On the 99% of the cases, Watson recommended almost the same treatment that was recommended by a cancer specialist. And in the 30% of the cases, the Watson also found the lacunas, the missing or the human errors that the doctors perform, and doctors agreed that they should have gone up with that kind of suggestions and agreed to Watson's suggestions. And there was some kind of treatment which doctors never thought, and that treatment came out of the journals which were published. And you will imagine that almost 160,000 journal research papers are published almost every year. The IBM Watson, fetch the required information from these 160,000 papers and suggested the treatment which doctors perhaps never gone through those papers. So that kind of help can flow from the AI technology. Other applications in the healthcare could be disease detection, diagnosing, prediction, drug discovery, personalized medicine, medical imaging, genomics, cancer research, brain tumor, in the dermatology, mental health, speech patterns, diabetes, radiology, acute kidney injury, especially the chatbots and the nursing assistants are available for the personal service. There are other benefits that artificial intelligence can offer to the healthcare sector, which can result into the new intellectual property. These benefits could be clinical decision-making, up-to-date medical information from journals, fetching the information from the textbooks and giving this information to the doctors, and offering the services like an experienced clinician. And also the AI offers tireless 24/7 service, which the human assistants may not be able to render. Can also offer services in the early diagnosis, prediction of outcomes of the disease as well, feedback on the treatments given to, and reinforce non-pharmacological management, reduce diagnostic and therapeutic errors, increase patient safety, and huge cost saving associated with the use of AI. AI has got a vast field that can be exploited in the healthcare sector, and we can come up with large number of copyrights, intellectual property rights.
Can you unmute yourself?
Gee, ma'am.
Yeah.
And as far as the healthcare sector is concerned, we have seen that technology has enabled now remote surgeries. 2019, Chinese doctors performed remote surgeries as far as 60 to 100 kilometers of distance. You find all these technologies can, if when they integrated with the healthcare sector, can result into large number of patents. Also, we are tying up with our pharmacy school. We are working on some kind of automatic insulin injection system. And this automatic insulin injection system was automatically derived out of the patient's data. So that meant we have the patient data. We use machine learning algorithms and came up with the working system that this is the architecture. I'm not going to go into it, but this will help the mankind, as well as we can come up with a large number of intellectual property, which is going to be very, very useful for the prosperity of this budding nation. What I wish to submit is the amalgamation of healthcare and artificial intelligence is the field which can be exploited for innovations and research. These innovations can lead to startups, as well as these innovations can lead to large number of intellectual property. The integrated field has a better potential to serve the mankind, also offering large number of opportunities for innovations and research, patents, IPRs, and startups. Intellectual property is a key to the nation's prosperity. We need to exploit the integration of the emerging artificial intelligence and healthcare sector to our own, as well as to the advantage of world. Ladies and gentlemen, I would like to congratulate the PhD Chamber of Commerce and Industry, Chandigarh and Punjab chapter, MSME DI Ludhiana, and I would also like to place on record my commendation for the School of Pharmacy, Panipat Institute of Engineering and Technology, for having taken initiative for such a wonderful occasion where we will have opportunity to learn and come up with large number of IPRs. And those IPRs, let me assure you, are gonna be good for the prosperity and economy of this great nation. Ladies and gentlemen, thank you very much. Ma'am, back to you.
Thank you, Shakti Kumar ji. It was a very insightful presentation. Just to put things into perspective, because today's seminar is on the healthcare industry, and just like Shakti Kumar ji's, has given his views on AI. AI, artificial intelligence, becomes a very important part of the healthcare industry, and with the growing technology, we are seeing innovations coming up into the artificial intelligence, getting linked with the healthcare industry, making predictive analysis and also analysis into the study of the disease and thereafter. Now, the question today and the reason for today's seminar is to integrate the technology with the patent application, in the sense that how to protect an innovation, or how to protect whatever, even if from a technological point of view, even if the artificial intelligence, some program has been formulated, something has been designed, or some predictive analysis can be made, if it is in a kind of a software, in that case, probably a copyright could be sought onto that. So the intellectual property right transforms as far as the healthcare industry across a number of channels. Just like Shakti Kumar ji just now said, that one channel is the artificial intelligence, in the sense that there is going to be something which is going to be abstract, there is going to be something which is going to be in the software form. That thing would be under a different category of it. I'm sure the speakers who are going to come thereafter during the course of this seminar would explain the difference between a copyright, a patent, and thereon and thereafter. But something very interesting that I heard just as I was listening to Shakti Kumarji was, see how vast and how integrated the healthcare industry and the intellectual property right has become. Not only are we talking about chemical substances which could be integrated into medicines and then patents could be sought onto that. There could be softwares which could be copyrighted, could be a part of the artificial intelligence regime. And interestingly also, from an industry which is of brick and cement, which means that there could be a possibility, let us say, even now today, PPE kits, masks, making a special PPE kits, or if there are certain sanitizers, those things are also going to be part of the intellectual property right if there is something that is out of the box or very different, which could be patentable. So the opportunity and the thought process, as far as your innovation is concerned, is unlimited. So we could be talking about a physical thing which could be patented, we could be talking about softwares, we could be talking about ideas, and so on and so forth. Just to let you know, it is not just the institutes and technology institutes and industry association and the associations and the industry which is working towards patents. The government of India also recognizes the importance of this thing and is working very closely with the industry and is trying to approach the, just like engineering colleges, medical colleges, pharmaceutical colleges, all these colleges, so that the concept about innovation could be started from an earlier age. At this stage, I would like to welcome Dr. Kundan Lalji. He's the Assistant Director, Government of India, Ministry of MSME. So he would like to put forward some ideas and thoughts of what the Government of India is doing for you, what opportunities the Government of India could bring forward for you, how the Government of India could provide a hand-holding support for the students. May I please welcome Dr. Kundan Lalji to please give his views onto this. Kundan Lalji.
Thank you, sir. Good afternoon to everybody. Respected Sri Ajay Mahajan ji, Convener, Jalandhar Zone, Punjab State Chapter, and Proprietor Uma International Jalandhar. Madam Rimneet Kaur ji, Deputy Director, PhD Chamber of Commerce and Industry, Chandigarh. Professor Dr. Shakti Kumar ji, Director and Program Coordinator, Panipat Institute of Engineering and Technology. Mr. Rakesh Tayal ji, Vice Chairman, Panipat Institute of Engineering and Technology. Sri Dr. Shweta Sen Thalwal ji, Founder and Head IPR, Intrigam IP Mohali. Ms. Deepika Divakar, Manikar, Co-Founder, Logicon Pune, Dr. Deepak Prabhakar Bhagatji, Principal, Department of Pharmacy, Panipat Institute of Engineering and Technology. My colleague, Sri Bajir Singh ji, Assistant Director, Ministry of MSME, Government of India, Department of Micro, Small and Medium Enterprise Development Institute, Ludhiana. First of all, I welcome to all of you on the behalf of Ministry of MSME, Government of India, Department of Micro, Small and Medium Enterprise Development Institute, Ludhiana. Sir, सबसे पहले तो मैं PhD चैम्बर ऑफ कॉमर्स एंड इंडस्ट्री चंडीगढ़ को कॉन्ग्रेचुलेट करना चाहूंगा, बधाई देना चाहूंगा कि उन्होंने ये जो प्रोग्राम ऑर्गेनाइज किया है। पंजाब में भी बहुत सारे इंजीनियरिंग कॉलेज के लिए ये प्रोग्राम इस तरह के उन्होंने ऑर्गेनाइज किए हैं, और आज का जो प्रोग्राम स्पेशली ये हेल्थ केयर सेक्टर के लिए रखा गया है, आईपीआर पर, इंटेलेक्चुअल प्रॉपर्टी राइट्स पर, और इसका एक बहुत बड़ा रोल है इसमें आईपीआर का। मैं जैसा कि अभी महाजन साहब बता रहे थे कि ड्यूरिंग द कोविड पीरियड बहुत सारे सैनिटाइजर, मास्क या वेंटिलेटर्स, इस तरह के बहुत सारी आइटम्स डेवलप की गई हैं। बट मैं आपको ये बताना चाहूंगा कि एमएसएमई मिनिस्ट्री का भी बहुत बड़ा इसमें रोल है कि एक तो सबसे पहले मैं थोड़ा सा मिनिस्ट्री के मैं आपको इनिशियली ये बताना चाहूंगा कि जैसा कि आप और हम सभी जानते हैं सदा कि 1 जुलाई 2020 से एमएसएमई की न्यू डेफिनेशन लागू कर दी गई है, और साथ ही जो उद्योग आधार मेमोरेंडम नंबर एक लीगल आइडेंटिटी एंटरप्रेन्योर की होती थी, उसको भी उद्यम रजिस्ट्रेशन सर्टिफिकेट से माइग्रेट कर दिया गया है। तो इसके लिए डेडलाइन माइग्रेट करने के लिए दी गई थी 31 मार्च 2021, बट इसको अभी एक्सटेंड कर दिया गया है 31 दिसंबर 2021 तक के लिए। तो सबसे पहले तो मैं आप सभी से मैं ये निवेदन करना चाहूंगा कि जिन्होंने भी अभी माइग्रेट नहीं किया है अपने उद्यम रजिस्ट्रेशन सर्टिफिकेट से, वो जरूर इसको माइग्रेट कर लें। और जो हमारी न्यू एमएसएमई की डेफिनेशन है उसके बारे में मैं थोड़ा सा ब्रीफ करना चाहूंगा कि इसको अभी चेंज कर दिया गया है, जो कि पहले ओनली इन्वेस्टमेंट बेसिस पे होती थी, अभी इसको इन्वेस्टमेंट एज वेल एज टर्नओवर बेसिस पर कर दिया गया है। माइक्रो के लिए इन्वेस्टमेंट 1 करोड़ तक का एंड टर्नओवर 5 करोड़ तक का किया गया है। इसी तरह से स्मॉल के लिए जो इन्वेस्टमेंट 10 करोड़ तक का और टर्नओवर 50 करोड़ तक का, मीडियम के लिए इन्वेस्टमेंट 50 करोड़ तक का और टर्नओवर 250 करोड़ तक का कर दिया गया है। मैं थोड़ा सा ये और बताना चाहूंगा कि माइग्रेट करते समय प्रॉब्लम्स थोड़ी सी आती हैं। अगर कोई भी किसी भी प्रकार की कोई प्रॉब्लम आती है तो आप हमारे ऑफिस में या हमारे करनाल ऑफिस में कांटेक्ट कर सकते हैं। साथ ही मैं आपको ये बताना चाहूंगा कि इसके लिए अगर कोई, जो कि महाजन साहब भी बात कर रहे थे, हेल्थ केयर सेक्टर में अगर कोई भी इस तरह का कोई इनोवेटिव आइडिया अगर कोई रखता है, कोई भी इनोवेटिव आइडिया, और उसको कोई कॉमर्शलाइज कराना चाहता है, तो उसको अगर वो कॉमर्शलाइज कर लेते हैं तो उसके लिए गवर्नमेंट ऑफ इंडिया ने एक बहुत बढ़िया हमारी स्कीम है, इनोवेशन की स्कीम है जिसका नाम दिया गया इनोवेशन। तो उसके लिए कोई भी जो हमारा बिजनेस इंक्यूबेटर है या हॉस्ट इंस्टीट्यूट है, उसके थ्रू अपने आइडिया को वो सबमिट कर सकते हैं, और जब अगर आइडिया वो अप्रूव हो जाता है तो मिनिस्ट्री की ओर से थ्रू हॉस्ट इंस्टीट्यूट या बिजनेस इंक्यूबेशन उनको 1 करोड़ तक की, उनको 15 लाख रुपए तक की ग्रांट एक आइडिया को नर्चर करने के लिए, कॉमर्शलाइज करने के लिए मिल सकती है। दूसरा, अगर उस इंस्टीट्यूट के हॉस्ट इंस्टीट्यूट और या मान लीजिए बिजनेस इंक्यूबेटर जहां पर वो सबमिट कर रहे हैं, वहां उनके 2 आइडिया अगर अप्रूव हो जाते हैं तो इंस्टीट्यूट को भी 1 करोड़ तक की ग्रांट ये हमारी मिनिस्ट्री की तरफ से मिल सकती है इंफ्रास्ट्रक्चर डेवलपमेंट के लिए। सेकेंडली, मैं आपको बताना चाहूंगा, आपको ये जानकर खुशी होगी कि एक मिनिस्ट्री ऑफ एमएसएमई की तरफ से पीएचडी चैम्बर ऑफ कॉमर्स एंड इंडस्ट्री ने एक जो आईपी फैसिलिटेशन सेंटर इस्टेब्लिश किया है अमृतसर में। ये इंडस्ट्री के लिए बहुत अच्छी सर्विसेज दे रहे हैं। हमने भी काफी यूनिट को इनको रिकमेंड किया है और कुछ यूनिट इनसे बेनिफिटेड हुई भी हैं और अभी अंडर प्रोसेस भी हैं कुछ के। तो मैं आपको ये बताना चाहूंगा कि आप पीएचडी चैम्बर ऑफ कॉमर्स जो इंडस्ट्री के लिए काम कर रहा है तो उनका भी आप बेनिफिट लीजिए। मैं आपको बताना चाहूंगा मिनिस्ट्री ऑफ एमएसएमई की 1 करोड़ की ग्रांट आईपी फैसिलिटेशन सेंटर इस्टेब्लिश करने के लिए इनको दी गई है। दूसरा जो आईपी फैसिलिटेशन सेंटर है वो ऑटो पार्ट्स मैन्युफैक्चरर इंडस्ट्री के थ्रू यहाँ पर लुधियाने में स्टेब्लिश किया जा रहा है, उनको भी ग्रांट सैंक्शन हो चुकी है उनकी भी। तो इसके लिए मैं आपको बताना चाहूंगा कि इसके साथ साथ अगर आप कोई भी पीएचडी चैम्बर के थ्रू कोई भी डोमेस्टिक पेटेंट अगर आप कराना चाहते हैं तो उसके लिए 1 लाख रुपए तक का डोमेस्टिक पेटेंट के लिए रिम्बर्समेंट है, और दूसरा फॉरेन पेटेंट के लिए 5 लाख रुपए तक की उसमें उनको फाइनेंशियल हेल्प उनको मिलेगी। तीसरा जो जियोग्राफिकल इंडिकेशन के रजिस्ट्रेशन के लिए 2 लाख रुपए तक का है, और ट्रेडमार्क रजिस्ट्रेशन के लिए 10,000 रुपए तक का फाइनेंशियल असिस्टेंस मिनिस्ट्री ऑफ एमएसएमई गवर्नमेंट ऑफ इंडिया की तरफ से उनको मिलेगी। और इसके साथ ही जैसे कि मैंने अभी पहले आपको बताया कि असिस्टेंस फॉर सेटिंग अप आईपी फैसिलिटेशन सेंटर, अगर कोई आईपी फैसिलिटेशन सेंटर जैसे आप हरियाणा में इस तरह का कोई आईपी फैसिलिटेशन सेंटर अगर स्टेब्लिश करना चाहते हैं तो उसके लिए 1 करोड़ तक की फाइनेंशियल असिस्टेंस या ग्रांट हमारी मिनिस्ट्री की तरफ से उनको मिल सकती है। तो ये हमारे कुछ मेजर एक्टिविटीज थी जो फाइनेंशियल असिस्टेंस या और ग्रांट जो हम इनको दी जा रही है पेटेंट के अंतर्गत। साथ ही कुछ माइनर एक्टिविटीज है हमारी, अवेयरनेस एंड सेंसिटाइजेशन प्रोग्राम ऑन आईपीआर पर अगर कोई करना चाहता है, चाहे वो आईपी फैसिलिटेशन सेंटर करता है, चाहे कोई इंस्टीट्यूट करता है, अगर मिनिस्ट्री से हमारी मिनिस्ट्री से उनको ये 70,000 रुपए तक की पर प्रोग्राम उनको ये ऑनलाइन अगर करना है, और सॉरी ऑनलाइन ऑफलाइन करना है, फिजिकली फॉर्म में करना है, तो उनको ये 70,000 रुपए तक की फाइनेंशियल सैंक्शन उनको मिल सकती है। इसी तरह से पायलट स्टडी, अदर स्टडीज फॉर सेलेक्टेड सब्जेक्ट क्लस्टर ग्रुप ऑफ इंडस्ट्रीज को 5 लाख रुपए तक की ये फाइनेंशियल असिस्टेंस मिल सकती है। नेशनल लेवल इंटरेक्टिव सेमिनार्स, वर्कशॉप, कॉन्क्लेव, कॉन्फ्रेंस, एग्जीबिशन अगर करना है तो उसके लिए 5 लाख रुपए तक की ये फाइनेंशियल असिस्टेंस है। साथ ही रीजनल लेवल इंटरेक्टिव सेमिनार, वर्कशॉप, कॉन्क्लेव, कॉन्फ्रेंस, एग्जीबिशन अगर ऑर्गेनाइज करना है तो उसके लिए 3 लाख रुपए तक का है। ट्रेनिंग प्रोग्राम्स फॉर एमएसएमई ऑफिसर्स और एंड आईपी फैसिलिटेशन सेंटर्स के लिए ये फंड्स इसके लिए रखे गए हैं 20 लाख रुपए तक के। अगर आईपी फैसिलिटेशन सेंटर के भी ऑफिशियल्स या एमएसएमई डीआई के ऑफिशियल्स ट्रेनिंग के पर जाना चाहते हैं तो उनके लिए है। इंटरेक्शन विद द इंटरनेशनल एजेंसीज के लिए 15 लाख रुपए रखा गया। तो इस तरह से ये हमारी कुछ फाइनेंशियल ग्रांट और असिस्टेंस ये हम मिनिस्ट्री की हैं जो कि मैंने आपके साथ डिस्कस की हैं। लेकिन मैं वंस अगेन ये मैं आपको कहना चाहूंगा कि आप ये पीएचडी चैम्बर ऑफ इंडस्ट्री एंड कॉमर्स जो चंडीगढ़ में है, जिन्होंने आईपी फैसिलिटेशन सेंटर, जिनके की इंचार्ज मैडम रिमनीत कौर जी हैं, डिप्टी डायरेक्टर पीएचडी चैम्बर ऑफ कॉमर्स के, उनसे आप कांटेक्ट रखें और जरूर इसका कोई बेनिफिट आप लोग लें कि किस तरह से आपने अपना ट्रेडमार्क रजिस्टर कराना है, डोमेस्टिक पेटेंट कैसे लेना है, फॉरेन पेटेंट कैसे लेना है, जीआई रजिस्ट्रेशन कैसे कराना, ये सारे फैसिलिटीज आपको आईपी फैसिलिटेशन सेंटर से मिलेंगी। इसके अलावा फिर भी अगर किसी को कोई प्रॉब्लम आती है तो यू कैन कॉन्टेक्ट एट आवर ऑफिस एट एनी वर्किंग डेज। हमारे सभी ऑफिसर्स यहाँ पर अवेलेबल हैं, वो आपको इसके बारे में गाइड करेंगे। तो मैं बहुत ज्यादा समय नहीं लेते हुए, क्योंकि आज हमारा एक दूसरा भी अभी हमने लॉगिन करना है जो कि हमारे हेडक्वार्टर से इसके लिए जिसमें कि बहुत सारी एक्टिविटीज हैं जिनके बारे में अभी वीडियो कॉन्फ्रेंसिंग है। तो मैं क्षमा चाहूंगा आज की थोड़ा सा शॉर्ट में मैंने रखा है इसलिए। तो अंत में मैं पीएचडी चैम्बर ऑफ कॉमर्स मैडम रिमनीत कौर जी और उनकी टीम को, श्री अजय महाजन जी को, सभी को बहुत बहुत इसके लिए थैंक्स भी करना चाहूंगा कि एक अपॉर्चुनिटी एमएसएमई डीआई को दी है कि हम अपनी जो स्कीम्स हैं उनके बारे में आपके साथ डिस्कस कर सकें। हमारी स्कीम्स तो बहुत सारी हैं, उनके बारे में हम डिटेल में डिस्कस करेंगे जब भी कभी टाइम होगा, तो आप हमें कांटेक्ट कर सकते हैं। तो थैंक यू वेरी मच मैडम और महाजन साहब,
थैंक यू वेरी मच कुंदनलाल जी। You are always very helpful, and it is nice to see that the government is making all efforts to support intellectual property right की जितनी exploitation है maximum हो सके, the government is trying for that. Now it is up to the entrepreneurs, the the intellectuals, the researchers to work onto that and to benefit from that. The PhD Chamber of Commerce and Industry is always there for you, to handhold you and to help you in this process. So I'm hopeful that we will all benefit from that. May I at this stage please call Dr. Rakesh Tayal ji. He's the Vice Chairman, Panipat Institute of Engineering and Technology, to give his address, please. Mr. Rakesh Tayal, please.
Yeah, good afternoon, everyone. It's very pleasant sight that we are seeing, the government side on the same platform. We are seeing, the representative from the industries, truly represented by PhD Chamber of Commerce and from the academia. The only problem which India faces today is like, these three different institutions don't come on a single platform, and that is the biggest problem. And now, if that initiative has been taken by the PhD Chamber of Commerce or MSME or any particular institution, it is like worth mentioning that India is on the right track. Not many things has happened because of this COVID, and the government also wake up to this particular call that now this is a time to work, and it is a time to collaborate together and work for a common goal. And that common goal is like, you cannot wait for the new researches and the technologies to come from the Western world. Now you have to do it on your own. You have to become self-reliant, and for that you need to spend on researches, and you have to rely on a collaborative effort. Right, alone it's very difficult to come up with some kind of innovations, because we lack in lot many different things. And is rightly expressed by the MSME that lot many grants are available, but the thing is how easily it is approachable to the industry or to the academia. That is a very important part, because the government makes lot many policies, but how these policies are implemented and executed, so that is the major challenge issue. But if it is in the hand of the very proactive members, as I was listening to Shri Kundanji, I think the things are going to change now, and we look forward to it. And if any kind of collaboration and things is required from our institution side, we are all in for that kind of collaborations. So we have recently set up the pharmacy department at our institution. It's hardly only 2 years old. So, but we are, at this point of time also, we are working on not many innovations and things. As एक चीज आपने भी पीछे बोली थी कि PP kit and all that stuff, because we are one of the few institution who started off with this kind of technology, and we were one of the few institutions who got the PP kit approved by DRDO, and then the whole Panipat industry started manufacturing PP kit. And now only we have made this oxygen concentrator also at our institution. So so the thing is we are ranked in 125 institutions of innovations and research by MHRD government, right? So but the thing is, like, if we really wants to make something into this healthcare, right, because this is the priority now for every country, for every citizen, right? And we need to come together and work on it and see that if your research is not properly protected, then also it's a big issue. Because we had one speaker, very young speaker, his age is only 25 years. I forget his name. So he developed some kind of a product through which he could purify water through pumpkin, right? But his product his research was not patented, and he lost everything, because there was a royalty which he could fetch from a American company that was worth around 1.5 CR per year. But later he realized that his research was in the public domain, and now he could not get that patented. So again he started working, and फिर उन्होंने जीरे के basis पे using that he purified water, And at earlier, when he got the efficiency of 65%, efficacy of, purifying the water. In the next research, he could do it by 95%. And then again, he got his product patented. And after getting the patented, he got 3 crores royalty from the same American company. And now he's the youngest CEO and MD of more than 10 companies. And he, do the funding for the venture capital to many youngsters and the startups. And they started with a very humble beginning. They, bought the books, from the Paharganj area and all that area where you have the Sunday market with, you get the very cheap books. So, वहाँ से metaphysics and all that stuff, they bought the books from there and they learned from there. So you can start your journey from anywhere. So there is no stopping, in that particular matter. But the thing is, you must have the learnings of how to get your research and innovations patented. And that is a very apt, topic of today's, this particular webinar. Then we must know that how to get this thing patented, right? So that you can really reap up the benefits of all these innovations which you do. So thanking you, thanks all of having me today. Thank you.
Thank you very much, Rakesh. It was really insightful. I'll just pick up a few points that you talked about, that your institute working on PPE kits, oxygen concentrators, and the like. That's a good thing about it. What the students need to understand here is that their innovation has to bring in some kind of an invention, and which is something which is non-obvious. So there has to be something which adds value to the invention and which is something very unique. Now, PPE kits and oxygen concentrators in the hands of a technology institute, in the hands of an engineering college, they could innovate and make changes into the process. But a mere change in the process is not likely to get you a patent. And at the very moment, Rakesh mentioned that one of the students, or one of his, the young guy, could not get the patent in the first place because the search was in the public domain. The purpose of today's seminar is to make the students aware of the pitfalls that they could fall in if they do not have the adequate and the right guidance as far as patents are concerned. Another thing that I need to pick on Rakesh is that he mentioned that it is heartening to see that the industry, the academia, and we've got people from the intellectual side as well who are representing the IPR, and all of us are getting together, even the government, and trying to make a better India wherein we could benefit from our innovation. India has always been on the forefront of innovation, but we have never been able to protect our rights. So there are certain things which are considered to be, knowledge which has been passed on from years and years and years, but we have never been able to exploit onto that. At this stage, I'm sure, Dr. Shweta Sen Thalwal, who's the founder and head for IPR, Integram, and she's going to give you a presentation. I've had the opportunity to listen to her on different occasions. So I'm sure she would give a very insightful presentation, and I'll pass on the forum to her and ask her to take over. Dr. Shweta Sen, please.
Thank you, Mahajan ji. So I'll be sharing my screen now. Yes, is this visible? Yes. Yeah. Is my screen visible? Yes.
Yes,
so,
it is.
Yes, I'll be discussing today about patent filing process in India and international aspects. So there will be comparison with US and UK systems also. So let us start. So everybody knows what is a patent. This is just an introduction. What is a patent? It is just a right or a legal document which is granted by a government, giving an inventor and applicant the exclusive right to make, use, sell an invention for a specified number of years. Specified numbers of years, it is mostly 20 years. A patent application in India is of many types. First, what we file is ordinary application. We draft a patent application, we file it. divisional application, if one application has, if one invention has two different patentable subject matter, they are filed as divisional applications. PCT international application, you can file your patent application as international application through PCT. PCT national phase application, which you enter into another countries by PCT. Application for patent of addition. Patent of addition is what, like you have filed a patent for something and you come up with some improvement over your your invention, or maybe you have come up with a different idea which is very similar to what you have filed, but yes, it has some inventive step over the already filed application. Convention application is similar to this international PCT international application, but it is filed from one country to the another country directly. You need not to take the PCT route. So these are different types of patent applications in India.
I'm not interested.
Pardon? Hello, Ramneet ma'am, is there a problem? Okay.
Ma'am,
So
you
what
can
rights
continue.
do, yes, okay, what rights do patents provide in India, as we discussed in the definition, and in Europe, including UK, the patent rights, the patent give the rights to exclude others. These are the negative rights from making, exclude others from making, using, selling, importing the patentable subject matter in your invention which has been patented. While in US, it is right to exclude others from making, selling. This is very small difference. Making, using, selling, offering for sale, importing, inducing others to infringe, applying for an FDA approval, and or offering a product specially adapted for practice of the patent. So patent application also gives you, by applying for a patent, you can also apply for a FDA approval in US. Second difference is applicant is one in India and Europe, which is first to file. Anybody who files first, whether he has invented it or not, the one who files it first will be the applicant. But in US, the first one to invent, you can prove that, okay, somebody has already filed an invention, applied for invention. But if you go to USPTO, that is a patent office in US, if you go to that and you prove that by your experimental diaries or data that I was the one who first invented it, you will be given the rights. But in India and Europe, there's no such provision. This is very common question we come across almost in every lecture. Is my patent valid in all countries? No. Patent is a territorial right. You file your patent in India, your patent is valid only in India. You cannot enforce your patent in China, in US, or any other country unless you have filed your patent in US or China or other country. Similarly, you filed your patent in US, you cannot enforce your patent in India. Your patent is only valid in US, except the European patent, because the European Patent Convention, they have made an original patent system which allows a single European patent application to cover the 38 member states across the Europe. So the European Union में जितनी countries हैं, उनको अगर आप एक यूरोपियन पेटेंट ऑफिस में अगर पेटेंट फाइल करते हैं तो आपको सारी 38 मेंबर स्टेट्स जो हैं उसमें आपको उसके राइट्स मिलते हैं. दिस इज ओनली फॉर द यूरोपियन पेटेंट इफ यू फाइल इन यूरोपियन पेटेंट ऑफिस. Now the next question comes, okay, what is patent? Why, like what rights will I get and what are the rights, territorial rights and everything. Now if the very question comes to mind, how do I know that my invention is patentable? So there's very simple thing, everything under sun that is made by man is patentable, and this is the statement given by the US Supreme Court while deciding a case in 1980, and that too was for deciding that genetically modified organisms, microorganisms, are patentable subject matter or not. And while deciding in favor of the scientist who made genetically transformed microorganisms, the Supreme Court said in US that everything under sun that is made by a man is patentable, provided in India and all countries which follow this, who have signed the treaty which comes under the TRIPS, that these three for invention has to be patentable. It must follow these three. It must clear these three criteria, that is novelty, commercial utility, that is industrial application, and inventiveness. What is novelty? Novelty means your invention should never be, it must not have been disclosed publicly before filing the patent. No paper should be published. No, nothing has to be done. It should not be discussed in public. No presentation has to be done. If you publish a paper, if you give a lecture about your, you've discussed in public about your invention, its novelty is gone. What is commercial utility? Commercial utility is industrial applicability, whether invention is industry, has some utility in industry or not. Inventive step, which is also known as obviousness. The inventive step means that could anyone skilled in the art have done it? Your peer, your colleague who is as expert as you in your field could have easily done it. If yes, it doesn't have any inventive step. If no, yes, it has some inventive step. So obviousness, it should not be obvious. Your invention should not be obvious, but this obvious word cannot be defined as such. So different countries have given different definitions for obviousness. In India, any feature, the feature of invention that involves technical advancement as compared to the existing knowledge, or it has economic significance, or both.
Dr. Shweta, ma'am, would like to interrupt you between. Our director, sir, has some query regarding this.
Yes, yes. Can we take queries? Yes.
Yeah, Dr. Shakti, if you don't mind, could we do that? Would we let Shweta ji finish the presentation and then we take the query? If that's good, all right with you, or Dr. Shakti?
My apology. I did not interrupt. There is some misunderstanding. My apology.
No worries. We'll just let her finish it, and then we'll come back to you as soon as she finishes her presentation.
Yes. Yes.
Right,
Thank
right.
you. Yes.
Please go ahead. Please go ahead.
Yes, for India, in India, the invention to be non-obvious, either it has some technical advancement in terms of knowledge, or it has some economic significance. You make an invention, you say that it is economic, it is cheaper than the existing one, it becomes non-obvious. For the like healthcare sector, we say that if you make antibiotic, or you put some essential oil in the antibiotic, or you add some chemical compound in the antibiotic, and efficacy of that antibiotic increases many folds. Say that antibiotic was curing a disease or infection when you consumed about 10 pills, and the 10 pills cost 500 rupees. Now the efficacy of that particular antibiotic has increased, and now you can take only 2 antibiotic pills and your infection is cured. So this becomes non-obvious. You have cut the cost of the antibiotic. Similarly, if you have some technical advancement over the existing knowledge, it also becomes non-obvious. In Europe, they have given some guidelines, some pointers, like choose the closest prior art. What is the closest prior art? Closest invention already existing in the existing globally. Then determine the technical problem. What was the technical problem before this inventor? Then examine the solution, and in the solution they see that was it very simple to do, was it very obvious, Was it very easy for the technical person of the same field or not? If answer is no, it becomes non-obvious and there's an inventive step. In US, they have also again given some pointers. First, they determine the scope and content of prior art. They analyze the difference between the prior art and the invention in question. They determine the level of ordinary skill in the pertinent art. What is the ordinary skill? Then they ascertain the secondary considerations of the non-obviousness. Secondary considerations are like, there's a problem which is coming from the ages and nobody is able to solve it, and somebody has come with a solution, and that solution may be very simple, but because it could not be solved for the ages, so the person has done something to solve it. He has got some inventive step, some invention, so it becomes non-obvious and it has some inventive step. So these are the different criteria laid by different countries. Now, okay, I've got it. My invention is patentable subject matter. My invention has novelty, patented, has industrial application, has inventive step. Now what? In India, there is another one thing. There is a section 3 and section 4. If your invention comes under section 3 and section 4, your invention is also not a subject matter, patentable subject matter. What is section 3? Section 3 is subdivided into many subsections, and that says that if your invention is just a discovery, you say that I discovered again the Newton's principle, or you gave us unethical, invention which is unethical, which is not which has no moral grounds, which is not good for the society, like you devise you make apparatus which helps in theft, which helps in gambling, which is for cloning. So these are not patentable subject matter. All the inventions related to medical cure and agriculture, horticulture are not patentable subject matter. You mix two things and say, I have mixed these two things and this is a new substance. This is just an admixture. It is not a patentable subject matter. You add two independent things together and say, I made different things, like you attach a torch to the umbrella and you say, now this is a torch with the umbrella and this is a new invention. No, this is not a new invention, but yes, you apply some sensors and you do some you add some sensors and say that when there is a dark and when there is raining, this torch switches on by itself, then it becomes a invention. But just joining the umbrella with the torch is not an invention. Now all these things have been sorted. Now your invention is a patentable subject matter. Now what to do? First thing, you will be providing your invention, disclosure of invention to the professional. It can be patent agent, patent attorney. Before disclosing your invention, you have to sign a non-disclosure agreement with the patent attorney so that he or she does not disclose your invention. Then he or she, the professional, will be doing the patentability search. They will be telling you that your invention is novel. They will be seeing that section 3 is not there in your invention and all these things. Then there comes the next step, that is decision to file an application for the patent. Now you have got the patentability search. Now it's your time, it's your decision that whether to proceed with the application or not. If yes, then there will be the patent drafting according to the Patent Act. Once the drafting has been done, then there will be the filing of the patent application. Patent application can be of two types. It can be provisional or complete. Provisional is without the claims and complete is with the claims. If you file the provisional application, then you have to file the complete application within the 12 months of the filing. Say you file today, within 12 months, you have to file the complete application. Also, if you want to go for international application, you have to file the PCT application within the 12 months from the first filing date, whether it is a provisional patent or the complete patent. But PCT application can be filed only after the complete patent has been filed. After this has been done, there will be the publication of your patent application after 18 months, which will be done by Indian Patent Office in their journal. If you want to expedite it, you want to publish your patent application early, there's also expedited provisions. And in these provisions, you can your patent application is filed within 15 days of the filing. Then after the publication is done, you can file for request for examination. You will be requesting patent office that, okay, this is my patent application number and please examine my patent application. And this you have to do within 48 months of the first filing. Then in response to your request for examination, the patent office will be issuing you a first examination report, and for which you will be responding to that objection, and you will be given 6 months. If your objections are waived off by the patent office, you will need to grant, else your patent will be refused. If your patent is granted, you have to file the renewal fees for next 20 years. So this is how the patent is. This is a complete patent filing process. Next is, if you wish to go for the patent cooperation treaty, that is international filing, this is the priority date. Priority date is the first filing date, whether you file the provisional patent or complete patent. This is the priority date. Within 12 months of this priority date, the first filing, you have to file the PCT, or you have to file, you can go for the conventional route. If you have chosen the PCT route, you can enter within 30 months from the first date into, you can enter into any country, any country you wish to choose. You see, you can, if you find that your invention is very, the market for invention is in China, you can enter China. If market is in Japan, you can enter Japan. In any country you wish to enter. PCT is a patent cooperation treaty which has been signed by almost 200 countries in the world. So you can enter into any country. What is the benefit of using this PCT? This PCT gives you additional 18 months to decide the market for your invention. Now, this is a very question which I got from when we were discussing earlier, that US or India, where to file for a patent first. Being an Indian citizen, see, US patent office is very lucrative and very for the inventors, also in India, because the market of US is very good for the inventions. But being an Indian citizen, we are under restriction that is given by the Patent Act, Section 39, that we have to file in India first. And why this provision? This is just for the sake of national defense and security. If some invention is very good for the Indian defense and security, and if we file it in US, then US will be taking advantage of it, not the India. So what this Patent Act has done, it has restricted the Indian citizens to file in India first. But if somebody finds that invention is but it is not a patentable subject matter in India, but yes, it is a patentable subject matter in US, or the market is in US only, not in India, then there is a provision which is foreign filing permission. You can write to the controller of the Indian Patent Office and say that you can write the reason and ask for the permission, and within 21 days the controller gives you the permission to file in the foreign. Else you file in India or wait for 6 weeks and file in US. You don't have to seek for the controller permission. Now the next question, that do you lose anything by filing in India first? No. you do not lose anything by filing in India. Why? Because India is a convention. India and US are in convention countries, and what the priority date you will get in US in India will also be accepted by the US Patent Office. So you file it today, and you file in US after 4 months or 6 months or 8 months, you will be given the priority date of today only in US Patent Office also. So we will not lose anything, even the priority. Except for this patents, which we are technical patents, which we are discussing right now, in some countries, except for India, US, Canada, and UK, most of the countries offer this utility models, petty patents, and innovation patents. What are these innovation patents or petty patents? These patents are patents which are granted for very short period of time. Normally the patents are granted for 20 years, but these utility models are granted for just from 5 years to 15 years or 10 years. Now, what is the difference? Both the patents should be novel. They must have industrial application, but for the petty patents, they do not have to be inventive. The inventive step criteria is not required for the utility innovation patent or innovation patents. You must have heard that Australia provides innovation patents, China provides innovation patents. There are many countries provide innovation patents except for India, US, Canada, and UK. So to get a innovation patent, it doesn't have to be inventive step, जिसको हम लोग second grade patents भी कहते हैं. और अगर Indians की बात करें तो we call it जुगाड़ू patents. जो जुगाड़ inventions होती हैं, to seek the patents for those, these are those patents. But in India, these are not. There's no provision for these. Now, coming for the types of pharmaceutical patents in India. What are the types of pharmaceutical patents in India? There's a drug compound patent. What is the chemical composition of the drug? If you come up with a new chemical composition of a drug, it is a patentable subject matter. There's a new formulation, composition of a patent. You add, let's say, you come up with something for corona, you add this gram of tulsi, you add this gram of this, and you come up with some different formulation for the COVID, it becomes a patentable subject matter. Synergistic combination patents. This is very synergism is a word which we see very frequently in pharma patents. Synergistic combination patents, if you say that you add two drugs, and if you add a drug for the headache and for the fever, and you come up and say, okay, I have got a drug which cure headache and fever also. No, this is not a patentable subject matter. But yes, if you come with something like we come with a drug which cures headache, fever, or something, cancer, or it is very, the efficacy has been increased, then it becomes a patentable subject matter. Like 1 + 1 is 2 is not synergism. 1 + 1 is equal to 11 is synergistic combination. Technology patents, polymorph patents, and process patents are also the patentable subject matter in India. Now, coming to the pharma patents, firstly, I'll be discussing about the US status. So this is a very interesting case. There is a drug whose name is Humira, which is the best-selling prescription drug in the world, with over 12 US billion sales per year. Initial patent on the product expired in 2016. 20 years were done on 2016, but within the 3 years before the expiration, the company applied for and obtained 75 patents that would extend its monopoly to 2034. And this is called the evergreening of the patents, which is possible in US, but not possible in India. few more examples. One of the most prescribed cancer treatments was approved by FDA in 2005, and this medicine is Revlimid. The patent thicket, that is, आप कह लीजिए कि this is the strategy to of evergreening of the patent, consists of 96 patents providing potentially 40 years without competition. So twice 20 years plus 20 years. Diabetes patients who rely on the insulin treatment Lantus may not see a generic alternative for 37 years due to the 49 patents issued. And this is the criteria. This is the case in US, and this is also, this has been given a term patent abuse also. So because in US, they give, there's a small modification, small improvement, and they give a patent for it. But in India, it is really difficult to get a patent for these small improvements, because in India, there's a section 3D, which says that various salt forms, esters, isomers, etc., which are similar in configuration, which in turn is likely to exhibit equivalent function, is not patentable. So you come with different polymorph, different salt forms with same efficacy. It is not patentable subject matter. It has to be therapeutic efficacy. A newly developed drug is patentable only if it gives a better performance, which must be proven experimentally. So this is the 3D, which is very relevant for the pharma sector in India. And this is the case in India, very popular case. This is Novartis company, which is a German pharma giant. This company filed a patent in India for this drug. This is imatinib mesylate, and the brand name is Livac. This is for leukemia. This patent was rejected. They've then litigated in the court, and this court also held the decision of the Indian Patent Office, because it was found that this Gleevec, that this patent for Gleevec was nothing, that it was only the modified version of an existing drug, which is imatinib, and therefore that drug was not innovative because they failed to show any therapeutic efficacy over the existing drug. So this was not granted in India, but if this was in US, it sure must have got the patent. With this, I finished my lecture. Thank you very much. Over to Mahajan ji.
Thank you very much, Shweta ji. It was indeed very, very, it was, you gave us a whole bunch of knowledge, and I'm sure the students would benefit from it. And as far as the other academia who would want to make use of their inventions and protect their rights. There are a few points that, for the benefit of everyone, I would like to just, I found it very interesting when Shweta ji mentioned that if you add something to an already existing, it is not patentable. While most of us do try to think, let's say you've made an oxide of something and the purpose of it remains the same, then it is not patentable. So something that you have to do has to be an innovative step. For example, there's dispirin that you take. वो 3 रुपए का पत्ता आता है, उसके साथ dispirin के साथ अगर आपने paracetamol जोड़ दी है, so it's also going to clear. So that is the incremental patenting is not part of the subject matter of the patents that would go onto it. So that thing is very clear that you need to come up with a innovative step into it. There's another few things just trying to link into it, because there might be more students of pharma, related to pharmaceuticals and pharmacy industry. At the very beginning, we talked about the artificial intelligence. Just as a thought, while we were thinking, if you have artificial intelligence, and if you've still built up something, a software which is going to cure something or give you an analysis into it, just like it was mentioned that there's an IBM Watson program which could go into the cancer research and could give you that. Likewise, I would say, like, you could correlate it to like playing chess, for example. If you're playing chess and there's a chess program that has been developed with a skill in which a grandmaster is playing against you, and all the chess the game is giving you some some suggestions. So that thing could be a subject matter of a copyright, and that software could be of that. So there is an integration of all the intellectual property rights as well as the pharmaceutical industry. The pharmaceutical industry does not have to limit itself to just the chemical composition, because earlier we talked about the PPE kits, the oxygen concentrator. These are brick and mortar products in which people. But if you can make a PPE kit, or if you can, just like I said earlier, if you can make something, there's no need to put a sanitizer onto your hands, or there's going to be a UV thing, which is very innovative. Even that is. So the pharmaceutical industry does not have to limit itself to the chemistry part of it, but there are the other domains also that you could be working on to it. I'm sure, the students would look into this, they would benefit, and PhD Chamber of Commerce is always there for you. And we have got all these, intellectuals with us, these, people who are experts in the intellectual property right, they could help you out. At this stage, I would like to call Ms. Deepika Divakar Panikar, co-founder of Logicon from Pune. May I please request Ms. Deepika to join us now.
Hello, everyone. Thank you so much for having me over. And as always, it's a pleasure to be associated with PhD Chamber of Commerce and to hear such promising ideas and concepts from all the luminaries gathered here today. So we have spoken at length about the concept of IPRs and the patents that can and that do exist in different innovations, inventions. That often brings us to the point of once an intellectual property right is established in a particular product, in some innovative process, or some innovative text, or so on and so forth, what next? All right, so your IP has been registered. Let's say it is a patent, your patent has been registered. What is the next logical step that is supposed to follow? And I think when each of us, or rather when many of us, we get into innovation, or when we get into creation of something, there is so much of our own thought and so much of our own intellectual property that we put into it, so much of effort, that we wish that that particular product, process, innovation also goes out and reaches the markets, the society, the economy benefits from it. And the process of benefiting the economy also benefits the creator of that intellectual property, and there is commercial gain for the creator as well. So without spending much time, I would like to speak to you about the different aspects of commercialization of your intellectual property, and what are the important contracts or the important documents that you may come across, or rather you would insist on having in your in your stockpile, so that each time you create an intellectual property and you want to go out to the market, either for commercializing it on your own, or tying up with some bigger entity so that they can manufacture it, you know what is the paperwork that should be in place, so that it is a win-win situation for everybody, and not a win-lose or a lose-lose. So I'd like to share my screen now. All right, so like we have already heard Dr. Sen and the speakers, the expert speakers talk about what are the different types of patents, the process for filing patents, and so on and so forth. So I wouldn't want to go too much into detail of what is intellectual property and what does it do for you, or what does it bring for you as an entrepreneur or as an innovator. Just a quick slide to tell you that basically the end game is that intellectual property rights, which are protected, which are filed, or which are registered, they, like Dr. Sen spoke about patents, they give you an exclusive right over your IP. So I think that's quite clear to all of us, that when we have created something, the best way to ensure that we are the ones who are controlling that intellectual property is by registering it, or by ensuring that it is protected in some form or the other. IPRs, or intellectual property rights, are very, very crucial for businesses, for young dynamic organizations, for startups, for entrepreneurs who are in the process of launching or innovating. While creating a new product can be exciting, challenging, rewarding, but without protection, it is not going to fly, as we say. It is not going to have the kind of impact, because anybody can come in and probably try to copy it, imitate it, and then how are you going to prove that this was your innovation, or this particular product or tech has been something where you have been the first one to create. However, second very important aspect after you speak about protection or registration of IP is to ensure that you have the right tools or the right approach for commercialization of IP, so that you can either engage somebody, some third party, to manufacture that particular patented product for you. That is one way in which IP can be commercialized. We are going to talk about it at length. Another way is you can collaborate with somebody who is working on something which is linked to your product or your IPR, and the two of you together can come up with a product which is higher in quality, in application, and so on and so forth. For all of this, you need solid documentation. You need solid contracts in place. This is something, so while we all often get very charged up about creation and registering, when it comes to the documentation, the paperwork, that is the place sometimes that we really fall short, or that is the place that we don't often give enough weightage to. But that is also the place that determines how our intellectual property, how our, if it is let's say some innovative PPE kit that speakers before me spoke about, how it's going to deploy into the market. What are the quality controls that are going to be in place? How are you going to price it? What is going to be the delivery schedule like? All these things are dealt with, can be dealt with very efficiently with watertight contracts and with paperwork. So when we are talking about IP, your documentation plays a very, very important role. Now, this documentation is not only once your IP is ready to be registered, but also one very important aspect is while you're creating this intellectual property, while you're putting together, let's say, a new cocktail for curing a medicinal cocktail for curing a particular disease or a particular infection, or if you are putting together an engineering process which helps the healthcare industry or which relates to health and wellness, all of these things, they need to be properly documented. So each and every step of your process, your drawings, how are you going about this IP creation? The more thorough your documentation, the easier it is for you to get protection. There are experts here who have dealt with IP protection matters. I'm sure Dr. Sen, who files patents and other IPRs, registration process on a frequent basis, she will agree with me when I say that sound documentation pre-launching your your registration process also comes in very, very handy. So especially for students and for young entrepreneurs, while we are creating, let us not get distracted from something which may seem very mundane or very boring, if I may say so, but which is going to be your shield when it comes to getting that particular patent registered in your name. So let us not forget that, and let us give due importance to your documentation as well. And then once your patent is protected, registered, then you come to the point of commercializing of that patent, or how is that patent, how is that particular intellectual property going to be beneficial for your business entity, for the economy at large, for the markets, how is it going to be useful? So while we talk about importance of intellectual property, especially in context of a young startup or in context of a young company or a business, one of the most beneficial benefits of IP, one of the most prominent benefits is it increases your business valuation. So let's say you have a pharmaceutical product, something which is very unique, very different, like the example of filtration process that was shared some time back through using jeera, or through using some natural products or things that are available outside. Now, if that kind of innovation has been created by you and you have the necessary registration to back you up, it increases your business valuation multifold. So investors are very, very eager to then invest in a company which is promising on its IP. Likewise, it becomes your brand identity. So it becomes something that your company is instantly associated with. And we, of course, cannot forget the first to market advantage. So when your patent is registered, when your IP, any other form of IP is registered, and you move to the market to commercialize it, to sell it, if I may say so, into the open market, that particular product becomes associated with, or your particular product becomes associated with that entire domain of products that relate to it. So how often do we say, let's order it off of, for example, Amazon, which was the first to market when it came to the entire online delivery of things? Or how often, I mean, I don't think any one of us even realizes when we say that, please get a particular paper Xeroxed, instead of saying photocopy, we don't even realize that we are talking about a particular company. So Xerox is the name of the company which makes photocopying devices and so on and so forth. So when you come first to the market with your intellectual property, that brings a certain excellent advantage to your organization and to your IP as well. Also, like I said, it helps you save time because you can always collaborate with people. So if you want new innovation to come about, you can exchange of IPRs, have a system in place, and so on and so forth as well. Certain crucial challenges that usually entrepreneurs, that young entrepreneurs and young innovators face when it comes to IP is, they have created something, but it is being copied. It is being used without the permission of that particular innovator or that particular entrepreneur. And here we talk about IP infringement. So something that has been created by one person or one entity, when it is being used by somebody else without their permission, that constitutes IP infringement. In simple terms, copying. And that can really cause a lot of setback. So here is where your registration comes in, because if your IP is registered, it becomes far easier to prove in the courts that you are the first innovator of this, and hence you are the person who has all the rights to this. Second very important aspect is IP non-exploitation. That means you have IP registered in your name, or you have created something, but you have not gone out to the markets to commercialize it. And that is, like I said, a lose-lose for everybody. That is a lose-lose for you because you are not being able to earn anything from that intellectual property. You're not being able to progress in your business and so on and so forth. Likewise, if the IP is not taken to the markets, that is also very bad for the markets and economy and the society at large, because something very good, some really beneficial innovation is being kept away from a large number of people. Their lives can get better after coming to know of this particular innovation. But unfortunately, because it is not being commercialized, it is not adding much value to anyone's life. Another very important aspect is IP under or overvaluation. That particularly happens when innovators are new, when they are young, dynamic innovators and scientists such as yourselves. Sometimes the exact valuation is not achieved properly, and it can go both ways. It can either turn investors against you, thinking that you are overvaluing your IP. If it is undervalued, it comes at a loss to you. So that, and I have already discussed improper record keeping and how it can cause a lot of setback to not just your processes, but it can actually mean the difference between getting something registered in your name and not being able to, because you don't have the necessary documentation to back it up. So improper record keeping is also very, can also be quite a big challenge. Now, when we speak about IP commercialization or IP contracts, this is the way we deploy, or I have listed before you the various manners in which intellectual property, patents, copyrights, but since I'm talking to pharmacists and tech and health oriented people, I will restrict myself to patents maybe. So this is how your registered patents get deployed. This is how they actually come out into the open market. So typically the ways that in which it happens is assignment. So you have created something, it is registered in your name. However, you are a small entity. Let's say you have created some very unique form of hand sanitizer, which probably functions in a certain exceptional manner. But you are a small entity which has created it. Maybe you're an individual entrepreneur or an individual scientist or a small entity which has created it. Now, after getting your patent, you want to go all out into the market. You want to try and push it out as much as you can. The way to go about it sometimes can mean can happen in the form of an assignment, wherein you assign it, you sell your IP to a bigger company or so on and so forth for a large amount of, for a large value. And that company then takes on that particular, or rather purchases that particular intellectual property from you, and then manufactures it on a very big scale. Assignment also typically happens when there is a founder who has created one particular unique product, and the product patent is registered in his or her name. And when they form a company, when they are trying to raise funds from investors, usually people tell them that the company needs to own the IP. So the founder who has created it, in whose name it is registered, sells it to the company, because after all, he is the founder of the company. So the company is very close to him. So he sells it or she sells it to the company, and the company then takes the product out to the market in various forms. So that is how assignment also plays out. That I'm talking about assignment of IP. And here you need a good solid assignment contract or assignment agreement in place to make sure that everybody's rights are protected. Now, talking about the most common way of IP commercialization, which is licensing. Like I said, something has been created by you as an individual or as a smaller entity. You want to control that particular product. You don't want to just simply sell it off to somebody else. Having said that, you do not have the ability to actually manufacture it on such a large scale. Maybe you are based out of a different country and the manufacturing is, or a different region in the country, and some other location is more suited for the manufacturing, or maybe you don't have practically that kind of setup to manufacture. Then in such a case, what you oftentimes do is called licensing, wherein you permit another entity to on the basis of the license to actually manufacture, produce that particular product, and then go out into the market for selling that product. So licensing agreements are some of the most common agreements. We have seen them very often. A lot of startups and a lot of young entrepreneurs, in fact, come to us and say that what is the best way forward? And many a times, instead of completely just selling it off in the form of an assignment, we tell them to choose the option of licensing. Then comes the very common in pharma industry, the concept of technology transfer. So how to manufacture a particular product, or how to get the right product manufactured is specialty technology that is sometimes shared from the person who owns that technology or who has created that technology with another entity. And that is what technology transfer means. So some very high level technology is created and transferred. And of course, all of this happens for commercial benefits. So there is a monetary value that exchanges hands, be it assignment, be it licensing, be it technology transfer. There is always either some form of license fee or some form of royalty or some one-time payment that always is associated with these particular modes of IP commercialization. Joint venture agreements and mergers and acquisitions are something that happen when two companies, two entities, two organizations are at equal footing on each other. Sometimes one has part A to solution A to a problem, the other person has solution B. A and B put together makes up for the best solution to a particular problem. Let's say A and B put together is the best medicine formulation or best medicine cocktail or whatever it may be for a particular situation. Sometimes these two come together. There are joint ventures, joint venture agreements that take place, and then both of them agree to work on merging or on rather processing their intellectual property together and reaping the benefits of it also together. Mergers and acquisitions, I'm sure all of you are very aware of it. One company, which is a smaller company, has created something very unique, has a patent registered in their name. So a much bigger entity comes in, and instead of buying just the patent, it completely takes over or acquires that particular company. So mergers and acquisition is not a very common way at your stage, but a very, very common way for, when IP is already created and launched and when bigger players are into the market. So that is another example of commercialization or deployment of IP. Now, we are running, I'm sure, short of time. So I just quickly like to flash before you certain strategies that innovators, inventors, scientists, basically anybody who is working towards intellectual property rights, towards securing a patent must deploy. And that is make your IP protection a priority. That is the most important thing. Let it not go to the back end. Let it be something that is literally, it can literally make or break a business or a startup or a young company. So make it a priority. Register IP rights. Very, very important for IP rights to be registered. Due diligence of IP rights means understanding, especially if somebody has told you that they have the IP rights to a particular thing and you are interested in any kind of purchase of those IP rights. Proper due diligence becomes very important. Policies, again, is something that is also quite crucial. And IP related agreements, time and again, I keep telling all the young dynamic startups, inventors, innovators that we work with, please prioritize on your paperwork also. Make sure that any licensing agreement that you may happen to sign off for somebody, you have a clear understanding, you have the right kind of help around putting those licensing agreements or any other agreements in place as well. So I have already spoken extensively about commercialization. Just flashing certain important aspects of licensing that I already spoke to you about. One very important aspect is it is not a sale. So while assignment is an outright sale, but licensing is only permission to use on certain agreed terms and conditions or to produce. So in the licensing domain, the creator of the IP still holds control to a certain extent on the IP, especially established through a licensing agreement. Sale or assignment, we've already discussed. Certain other agreements or certain other documentation that should have good, robust IP clauses are non-disclosure agreements, your NDAs. They become very important, especially in the initial times when your IP may not have been protected. If two or more people are working on a concept together, to have a co-founders agreement so that there is clarity of who owns what aspect of the IP, equally important. Joint venture agreements, your vendor agreements, all these aspects are really crucial when it comes to actually deploying your IP. Yeah, that just brings us to the end of what I wanted to share with you all. Basically, solid paperwork wherein there is a clear stating of all risks, the rights, obligations of all parties, secure paperwork that each party is aware of when they have executed it. All of it contributes towards making the IP very, very secure, and also deploying it in the market so that it fetches maximum benefit to everybody. So it's a win-win for everybody. So thank you so much. That is about it for me. And over back to Mr. Mahajan.
Thank you. Thank you, Deepika ji. It was really good and very exhaustive. Thank you for your time. Really appreciate that. I'm sure everybody would have benefited from that. Are there, at this stage, we could take some questions. Are there any questions that we could take? The experts are here, they could answer that. If there are any questions from anyone, from any one of our participants.
Yeah, participants, they can show a raise of hand and then we can unmute them. Or they can write in chat as well.
While you all make up your mind, let me share an antidote with you, which would keep you occupied for another 5 minutes till the time you come up with a raise of hands. Each one of you must have heard about AstraZeneca, the vaccine, what we call Covishield in India. But you'll be surprised to know that there's a company called Lee Pharma, which did a case against AstraZeneca to force AstraZeneca to give up the salt. But this is in 2015, let me remind you that. So we are talking about 2015. Now हम 2021 में बैठे हुए हैं, and we are talking about Covishield. But the pharma industry has always been at the forefront of IPR, in the sense that they've always filed patents and they've always tried to protect their rights. So Lee Pharma और AstraZeneca का केस ये हुआ था कि AstraZeneca ने कोई दवाई बनाई. It was for diabetes. So Sexapilatin, something like that, the name was that, but that was in 2015. And then the case was filed by Lee Pharma कि AstraZeneca जो ये salt है ये हमारे को दे ताकि हम इसको market कर सकें. AstraZeneca has not been able to exploit it. Just like a little while ago, Deepika Diwakar ji mentioned that आपका जो patent है वो commercially exploit होना चाहिए. That is one of the pre-requirements that it has to be. If it is not being pre-exploited, then there is something called compulsory licensing that comes into play. एक case हुआ था Bayer versus Natco, which was a very famous case in which the compulsory licensing came into effect. और जो ये compulsory licensing का था, अभी जब हमारे ये vaccination का process चला है, there was a lot of talk that the Supreme Court did write to the government of India that why the compulsory licensing could not be done in this particular case. Fortunately, what has happened is AstraZeneca and all those companies they are giving the medicine at a very lower cost. That is why compulsory licensing has not kicked in. Whereas in the Bayer versus Natco case, what had happened was कि जो मेडिसिन बन रही थी वो बहुत महंगी थी. It was like 2,88,000 की एक वायल थी. और वही मेडिसिन अगर आपको 20-25 हजार में मिल रही है तो that is beneficial. So the government can also take away your rights and patents as far as the pharma industry is concerned, if it is in the benefit or the interest of the public in general. So our sections from 84 to 99 of the Indian Patent Act relate to that. But that is not stopping you from inventing something. That is just to tell you that patent works in the best interest of the general public. So the invention has to benefit the people. And आपने अगर इन्वेंशन कर ली है उसके बाद इन्वेंशन को आप हमेशा के लिए नहीं उसको रख सकते हैं. There's a period of time. Let us say there's a period of time in case of patents for a period of 20 years. After that, it will come into the public domain. People can exploit it, and that is why people make generic medicines after that period is gone. और इससे थोड़ी देर पहले श्वेता जी ने बात करी थी जो इंक्रीमेंटल पेटेंटिंग की और एवरग्रीनिंग ऑफ पेटेंट्स, यानी कि आप ये नहीं कर सकते हैं कि आपने एक सॉल्ट बनाया है तो उसके साथ आपने एक थोड़ा सा वो और कुछ ऐड कर दिया तो वो that could be patented. No, that cannot be done. It has to come into the public domain. I hope I've done my 5 minutes part of it. If there are any more questions, we'll take those questions. Are there any questions?
We again request participants to kindly show a raise of hand for any query, or you can write in the chat box. We'll answer the same.
Ma'am, I have got one query on off-label medicines. Like off-label medicines are those which are not approved by any of the FDAs, like US FDA or Indian FDA for a particular ailment, but they have been prescribed by the doctors or physicians for other ailments without the approval of the drug for that particular ailment, but they have proved very beneficial in the management of the disease. For example, remdesivir, for example, which is not a cure for corona disease, but lots of people have got benefited out of that. So even in ivermectin case, it is not indicated for the treatment, but it some of the other way around alleviate the symptoms rising from that. So do we have any kind of reason to file patents for such medications where we have conducted some clinical trials on off-label medicine?
Would one of the experts want to take on to the answer?
Yes. Yes, Dr. Deepak, your question that off-label medicines are, I don't, for ivermectin, there's already a patent, and patent is already expired. And I don't think in India, the different use or is not patentable subject matter of the same existing salt. So I don't suggest one should go with filing for these
because
salts.
I have seen patents of the molecules which are having a patent done for one particular case. For example, there is a molecule which we have isolated from a plant, Nirgundi. It was indicated for liver ailments, but it has proved beneficial for so many different more ailments. I'm not right now discussing because I'm in a process of patenting it. So I'm not disclosing it for what I have explored the molecule, for example. But this is what I wanted to ask, because then I can file the patent accordingly.
Yes, as far as I could understand your query, in India only the molecule is patentable, not its use.
Okay. And
Only
what
the
about the
molecule.
process patent? Because
Yes,
if we change the
process of extracting that particular molecule is different, or it is way cheaper, economic, then it is patentable.
Okay. Okay. Thank you, ma'am.
I think.
Any other query? Otherwise, sir, we can close this session.
Right. If there are no other questions, if there are no more queries, may I please request Dr. Deepak Prabhakar, Principal Department of Pharmacy, Panipat Institute of Engineering and Technology, to propose a vote of thanks, please.
Thank you, Mahajan, sir. First of all, it is a matter of pleasure for me to propose the vote of thanks to PhD Chamber of Commerce and Industry for giving us the opportunity to collaborate for this important webinar session. The partnering organizations for this interactive video conferencing on patents and the healthcare industry. To be very specific, to the PHDCCI, MSMEDI, Ludhiana, and our institution PIET. I am grateful to the Diamond, Platinum, Gold, and Silver sponsor for their immense support in organizing this event very successfully. I am thankful to the esteemed speakers come panelists for this webinar. Firstly, our program coordinator and our worthy director of the Panipat Institute of Engineering and Technology, Professor Dr. Shakti Kumar, who is globally acclaimed scientist, educationist, policymaker, and a wonderful mentor for delivering his enlightening address on the significance of the intellectual property in the growing artificial intelligence and the healthcare industry. It was really a mesmerizing talk for the young researchers, paving for their filing their incredible and novel research for the patents. He enthralled the participants with his thoughts on emergence of AI in healthcare and various applications of AI, such as to assess the physicians, early diagnostics, and the treatment of the same. I'm indebted to our Vice Chairman and a visionary educationist, Mr. Rakesh Tayal, for his novel ideas, clear vision in transforming the education and research to new domains, entrepreneurship, and skill development. He said it is the need of the day to become self-reliant, and this can happen with the collaborative efforts with different institutions such as PHDCCI, MSMEDI, and so forth. In spite of the technical glitches and his professional appointments on today, he spared his invaluable time to address the participants with his noble thoughts. I am very much thankful to Shri Kundan Lal ji, Assistant Director of the MSME Ministry of MSMEDI Ludhiana, and he gave a very nice overview about various schemes and grants that are offered by MSMEDI for the young researchers and the people who would like to associate for different kinds of novel ideas. He said novel ideas that can be submitted by colleges for the development of the infrastructure. The MSMEDI would be pleased to grant about 1 crore for the infrastructural development. I'm also very grateful to Mr. Ajay Mahajan, sir, the convener, Jalandhar Zone, Punjab State Chapter, proprietor, Uma International. He wonderfully moderated this session and conveyed about the awareness about various patents and research that has to be generated in these students. They need right guidance so that they could come up with good ideas and good research work. Dr. Shweta Sen, ma'am, I am really thankful to you. Dr. Shweta Sen, ma'am, is the head IPR Integram IP. She gave a step-by-step guide of how the patenting filing process is done. And she also enlisted about like country-specific patent rules and how can we go about patenting by selecting different countries. And she also made it very clear about why should we file an Indian patent than US or others. That is for the Indian defense and security reasons. It was also informative session about that increase the knowledge of the pharmacy professionals about various types of pharmaceutical patents that are available in India for patenting. I am also thankful to Ms. Deepika Divekar Panikar ma'am, the co-founder of Logicon Pune. She emphasized on ensuring the right approach of the commercialization and collaborating with some organization which is also have the same area of research to improve the quality and documentation of IPR, especially the patents. She also said that the importance of intellectual property is one of that increases the business valuation and become your brand identity. As far as various challenges to IPRs are concerned, there are some issues pertaining to IP infringement, improper record keeping, IP undervaluation, IP non-exploitation, etc. And thank you very much, madam, for your deep insights, your thoughts in a very practical way and in a way that is easy to understand for any upcoming scientists and researchers. And it was really, really very great way that we have begun with this kind of webinar so that our students could also get some better insights about it. I am delighted to have PhD Chamber of Commerce and Industry Punjab chapter. Especially, I would like to thank Mr. R.S. Sachdeva ji, the mentor, Mr. Karan Kilhotra ji, the chair, Mr. Simran Preet Singh and Mr. Bharat Singh Mehta, who are the co-chairs, Madhu Pillai ma'am, who is the resident director, Rimnit Kaur ma'am, who is the Deputy Resident Director of PHDCCI, Sumit Kumar ji, who is the Executive Officer of PHDCCI, to whom I was associated for lots of discussions, and even to the Rimnit ma'am also, so that this kind of good discussion could emerge out. I am thankful to my fellow colleagues, deans, HODs, dear students of various departments of Panipat Institute of Engineering and Technology for actively participating and registering. I'm very happy to share that we have crossed 140 plus registrations in a span of only 2 days time. So thank you everyone for their active participation in this webinar and made it a grand success. Apart from this, I would like to thank the colleagues and associates from Doaba College of Pharmacy, Kharad, Hindu College of Pharmacy, Sonipat, ISF College of Pharmacy, Moga, Punjab, Chitkara University, Punjab, Amar Shahid Baba Ajit Singh Jujhar Singh Memorial College of Pharmacy, Bela, Ropar, Punjab, Baddi University, Baddi, Dashmesh College of Pharmacy, Faridkot, Swift College of Pharmacy, Rajpura, MET University, Noida, Jaipur, and Kolkata. So we have got registrations from every nook and corner of the country. So I'm very happy that in these 2 days the program was planned and made it a grand success because of the collaboration and efforts that our Vice Chairman sir, Director sir, Mahajan sir, and even ma'ams, everyone said about like collaborative work always leads to the success. So thank you very much, and also the media, press, and everyone, and all the organizing committee members who I have missed the names of. So I really would like to have a pardon on that because I do not know the names of each and every person. So with this, I would like to thank everyone. Thank you, sir.
Thank you very much, Dr. Deepak. And I think it's my turn to thank you after you've thanked everyone else. So thank you very much. Over to Rimnit ji.
Thank you, sir. It was quite elaborative and detailed. Vote of thanks. And you didn't miss out any name. I think so. And secondly, sir, you can get in touch with us for any IP registration since we have our IPFC center. So we'll share the details of the IPFC registrations and we'll also share IPR MOU with you. So you can have a look and you can further take up with Shakti Kumar sir and all relevant concerned officials to take forward. Sure. And this is the starting of the first session, and we look forward to many more sessions with you.
Yes, ma'am, thank you so much. And we would also appreciate if you could visit sometime at our campus because we have got very good infrastructural facilities, and we have also came up with some of the startup conferences in the recent past. So we also are coming up with a very one of the biggest incubation center in the Haryana state. So this could be a good training institution for the people who are, in the North India, who are living in the North India, or working in the North India, and they would be getting training here in association with PHDCCI and the mentoring team as given by PHDCCI, MSMEDI. Thank you so much, ma'am, for giving such a nice opportunity.
Thank you. First, thanks to you. You collaborated and we went ahead with the event. Thanks to you and Dr. Shakti Kumar sir, and we look forward to collaboration with you.
Thank you so much, ma'am, for
your kind words. Thank you, everybody. It was a wonderful session. Thank you so much.
Thanks all panelists and our participants. Thank you.
Thank you.
Thank you. Thank you.